Yes, sir, you may start. So today topic we will have is general defenses and right to private defense in criminal law.
Yes,
So, sir, you may start.
and I would like to first let you know something that you make sure that you have some bare acts, okay, from IPC for your better understanding. Because I go by one section with illustration or examples with case laws. So make sure you have some bare acts of IPC. It will be better. So, so let's start now.
Yes, sir, you can, sir.
Okay. So, so today I'm going to discuss about some general exceptions or differences of in the criminal law. So before going through the sections, I just like to make an introduction regarding this general exceptions. The main object of this general exception is that it's normal what happens now. If anything, if a person crime has been committed, you have to try by before the criminal court. So before making a judgment, before giving an judgment, or making the person to be conviction, the court granted an opportunity to the accused to whether prove themselves whether he is guilty or not. That means you have to establish in his or her part whether he is guilty or he or she is guilty or not. So that in that in that part, in that opportunity, that's in the opportunity, the general exceptions comes under that opportunity. So these are the and opportunity in the sense, man, that means the exceptions. That means the person or the accused, there are certain circumstances in which the accused has been exempted from guilty or from making any convictions. So that part has been defined and has been mentioned in chapter 4 of IPC. That's from section 76 to 106. So now we are going to start from 76. 76. There is a mistake, but when I'll prefer reading from by combining sections. Suppose because there are some sections are very correlative. So if I'll go one by one section, maybe you'll get confused. So I'll combine the section like mistake. In mistake, 76 is saying that act done by a person bound by mistake of fact, believing himself bound. So mistake of fact and mistake of law, they're both related. So that means section 76 and 79, you have to read together. Okay, so 76 and 79, we are going to read together. So please just go to the sections first. What the section is saying. Just let me read that section to you. 76. Nothing is an offense which is done by a person who is or who by reason of a mistake of fact and not by reason of mistake of law in good faith believes himself to be bound by law. So there in this part there is two parts. One is mistake of fact and one other is mistake of law. So and please write down the maximum. I'll just tell the maximum from her defined from mistake of fact and mistake of law. There is a maxim that ignorantia facit excusat and ignorantia juris non excusat, means ignorance first, ignorantia facit excusat. That means ignorance of fact is an excuse. For example, the latter I'll tell later. I'll tell about the ignorance of fact, regarding about the fact, mistake of fact. Okay. Mistake of fact, what is a mistake means it's an erroneous act. Someone that does not mean that you are carrying a gun, and when police drag you, police found out that you have a gun, and you can take a plea that I don't have any idea what the gun comes from. So I don't know about my gun. That cannot take a plea. Mistake of fact means mistake means what? It's the erroneous part. You have no idea what is. It's an erroneous. It's a simple mistake that can be excusable. For example, there is a. I'll first go through the example. There is a illustration is that a soldier fires on a mob by the order of his superior officer. His conformity with the commands of the law, he has committed no offense. Now come to the section. Nothing is an offense which is done by a person who is or who by reason of mistake of fact and not by reason of mistake of law in good faith believes himself to be bound by law to do it. There is two parts. First is that who is done in by mistake and in good faith. A soldier, for example, is a soldier fires on a mob by order of his superior officer. That means he have done by the order of his superior officer and in conformity with the command. That means he have to obey or make an obligation to his superior officer. So here A has committed no offense. And second, there is a second example. A, an officer of court justice being ordered by the court to arrest Y, and after due inquiry believing Z to be Y, arrest Z. A has committed no offense. That means by mistakenly, a police officer mistakenly knowing that A is not Z. So that means mistakenly arrest that person with believing that he is Z. That means he's an accused. So that is a mistake, and that part is excusable. Now the police officer can take the plea that it's only a mistake of fact, and this thing has been mentioned in this section. For more better example, there is a famous case, R versus Mr. Tulson. What is in this case? The fact is, Mrs. Tulson married to Mr. Tulson in September 1880. Her husband deserted in 1881. That means lives in 1881. But Mr. Tulson whereabouts were unknown for more than 7 years. See, Mr. Tulson, he does not show up since 7 years. So see, his wife made all inquiries, all fine, she has made all inquiry about her husband, but learned from reliable resources that he died, or he means her husband has been died in a shipwreck. So again, Mrs. Tulson, after confirming that she has died, Mrs. Tulson got married in 1887. Reason of believing that her husband is dead. So soon after time her marriage, her first husband the dead husband reappeared again and charged for file a petition before the honorable court for bigamy. Now the trial court convicted the trial court convicted his wife, but she makes an appeal, go for an appeal, and was acquitted on the ground that she had no menstruation. So first thing, she have no menstruation. That means there is no mental element. She has not been any guilty intent, to cheat her husband. And secondly, Mrs. Tulson in getting remarried under the belief that her husband's death. So it is a mistake of fact because she had made all the inquiries. Whatever she have to do, she have made all the inquiries from her part. She has done her part, getting from he has confirmed from her reliable sources that he has been dead. That's why she has been remarried. So in that between by basing on two condition, means and the mistake of fact, the defense she has been acquitted from the bigamy. So this is a part of mistake of fact. So it is pure excusable. Now comes the mistake of law. The maxim is saying ignorance of juris non excusat. That means ignorance of law does not excuse. That means if whether we are layman or knowledgeable person, ignorance law means everyone is punishable under the law. So if we ignorance of law is not an excuse, it must be punished. Let's have some that is mistake, ignorance means mistake of law. This is 79. Then comes the 79 section. I'm just reading the section. An act done by a person justified or by mistake of fact, believing himself justified by law. Nothing is an offense which is done by any person who is justified by law or who by reason of mistake of fact and not by reason of mistake of law, in good faith, believes himself to be justified by law to doing it. First, go to the illustration. First, it will be better understand if we go through illustration fast. A sees Z commit what appears to A to be murder. A, in the exercise of the best judgment exerted in good faith, on the power which the law gives to all persons exerted, the law gives all persons apprehending murder in the act, says Z in order to bring Z before the proper authorities. Yes, what is saying that A sees Z commit what appears to A is murder to A. But A says that Z has going to commit a murder. Now what happened? A thought that Z is going to commit an offense in order to prevent that murder, prevent the committing of any crime. A has seized Z and bring before the police station or proper authorities. That means A has committed no offense because though he may Z acting as a self-defense, but A perceived that there must be commission of any crime. So A has done that act in good faith. So now please mark the last sentence of the section. Mistake of not by reason of mistake of law in good faith, believing himself justified by law to doing it. So he has done this act which is justified by law because he doesn't have any guilty intention and he has done everything for his good faith. So in two parts, he has been excused from committing any offense. So that is mistake of law. This is all about. There is another case law. Please note down. R versus Bailey in 1800. R versus Bailey, year of 1800. I'm just telling the fact that in this case, an accused was away from the coast of Africa when the statute was passed by the British Parliament, and he even could not have known by any means about the passing of statute under which he had charged. No, in this case, what happened? The accused was been deserted or has been absent from his hometown since two to 3 years, and in that 2 years, the British Parliament has been made a statute, make a new law, and the person does not have an idea about the new law. And later, he has done an act that before 3 years that was not offense, but after 3 years, the act makes the act itself as an offense. So the British government charged that he has committed a crime, and the court held him that disallowing his plea out of. Now the accused pleaded that I don't have any knowledge about this law. I don't have any knowledge about the law passed by the British government, and that plea has not been taken into consideration, and the person has been guilty for the act he has done. So that what the conclusion is that ignorance of law. If you cannot plead that I don't have any knowledge about the law. So if you have any commit against the law or system, then you have to be punished. So this is the mistake of law, and this is not excusable. Then we come to Judicial Act 77 and 78. Second part is first one is that the mistake that comes down two parts, mistake of fact and mistake of law, section 76 and 79. Then come to the Judicial Act 77 and 78. So you have to read both sections together. So, but you get understand very clearly Judicial Act. So now come to the section 77. I'm just going to read it. 77 is the act of judges when acting judicially. Nothing is an offense which is done by a judge when acting judicially in the exercise of any power which is or which is in good faith he believes to be given to him by law. What is saying that clearly the section 77 protects the judges from criminal process, just as the there is also Judicial Officers Protection Act 1850 also applicable, save them from civil suits. This 77 section protects the judges from any criminal liability, and there is another act, that is a Judicial Officers Protection Act 1850, which prevents from any civil liability, civil suit liability. So please write down that act, Judicial Officers Protection Act 1850, protects the judges from any civil liability. So let's go through. That means by saying if any order passed by the judge, which may be been by mistake or anything, which be wrongly ordered by judge, that means the judges will not have liable for that order, for their judgment. They have been exempted from that liability. That this the thing has been mentioned in section 77, that act of judges when acting judicially. When the judge act in judiciary nature, they don't be liable for any order passed by them. Then come to section 78. Section 78 saying act done pursuant up to the judgment or order of the court. It's saying that nothing which is done in pursuance of or which is warranted by the judgment or order of the court of justice, if done while such a judgment or order remains in force, is an offense, notwithstanding the court may have had no jurisdiction to pass a judgment or order, provided the person doing the act in good faith believes that the court has such a judgment. Saying that section 78 is a wider perspective than the section section 77, is saying that it affords protection to officer acting under the authority of the judgment or order of court justice. That means if someone if the authority of a court, authority of a judgment, authority of a court who are carried out their judgment, they are also exempted from any type of criminal liability because they are carrying away the court's order. So they won't be held liable for any order passed by the court. So these are the relative parts, section 78 and section 77 and 78. 77 is clearly protects the judges, and 78 simply, I'm just differentiated. 78 is clearly also exempting the person or the authorities who are carried out the judgment. Okay. Then another important part is accident part. Section 80 about saying about the accident. You will generally know about accident, it's a misfortune or it is a unforeseen action. It happens sometimes. If any person has committed any crime and he proves that the crime or the offense has been done in an accident, the person also exempted or has been excused from any type of criminal liability. So now, in section 80, there must be some essential condition must have been fulfilled. First one, that there must be an absence of mens rea. That means there must not be presence of mental guilty intention. First thing is that there is absence of mens rea. That means without any criminal intention or knowledge. Second, in the doing of lawful act by lawful manner or by lawful means. And thirdly, the act has been done with proper care and caution. So these 3 or 4 elements must have been fulfilled in order to prove that the thing has been committed, the offense has been committed in accident. And if all the conditions have been fulfilled, then the court grants an exempted, and he will be get exempted from any criminal liability. So now read the section. Come to the section what is saying. Accident in doing a lawful act. Accident in doing a lawful act. So nothing is an offense which is done by accident or misfortune and without any criminal intention. So please read mark these points. Without any criminal intention or knowledge, in the doing of a lawful act in a lawful manner. Doing of a lawful act in a lawful manner by lawful means and with proper care and caution. So there are 3 essential ingredients as I said. Without any criminal intention, without any criminal guilty intention or knowledge, criminal knowledge. Second is that the law that's what's done in lawful act in lawful manner or in lawful means. And third is the proper care and caution. The act must be done in proper care and caution. So now read the example. The illustration is saying that is at work with hard chat. The head flies off and kills man who is standing by. Here there was no want of proper caution on the part of him, so his act is excusable and not an offense. It's a is at work with hard chat. Hard chat in the sense man, hard chat in a hammer, doing in a hammer, working in a hammer. And so that hammer fit out the slip hand and slip and it's kills stuff off and flies off and put and kills a man who is standing this near to this wall, near to the scanty. So he has done maintain all the proper care and caution. But after getting all the things, the person has been killed. So in this case, the act is excused and not an offense. So this person has been granted, has been excused, and has not been penalized because he has fulfilled all the condition. 3 condition has been met. Condition that is he does not have any criminal intention. He he is doing his act with with proper care and caution and in the lawful manner. So after carrying all this essential condition, still the person has been. That's why he has been excused from any criminal liability. There is another case, State of Orissa versus Khoragas, 1978. The case is that the accused a travel in a forest with a bona fide intention, shot an arrow at an animal, but a human being was hit by an arrow and died. So the Orissa High Court, allowing the defenses of accident under Section 80, acquitted the accused. So even in the tribal area, we are just trying to hunting an animal, but accidentally a human being shown up and has been killed. So the Odisha High Court, allowing the defense that it was the crime has been done, the accident, the thing happened on the basis of accident. So, and in the basis of that evidence, the Odisha High Court allow him or exempted from criminal liability and acquitted. So this is all about accident. Then second is necessity. That means necessity in the means section comes under section 81. Please, I'm going to read the section 81 saying nothing is an act likely to cause harm but done without criminal intent and to prevent other harm. So nothing is an offense merely by reason of it's being done with knowledge and that is likely to cause harm. If it's done without any criminal intention to cause harm in good faith for the purpose of preventing and avoiding other harm to person and property. So I'm just reading the main essential part to fulfill the section 81. The following condition ingredients must be satisfied. First, the act must have been done under good faith. They said mentioned in the definition part. First one is the act must have been done under good faith, and second, there must not be any mens rea. And please write down there must be any mens rea. Now come to the example. There is an example A in a great fire pulls down houses in order to prevent the conflagration from spreading. It does this with the intention in a good faith for saving human life or property. Here, if it be found that the harm ought to be prevented was such a nature and so imminent as to cause excuse A act, A is not guilty of the offense. What happens now? There is an A was standing over there and she saw that there's a fire broken up in a house, and he thought that if I pull down the house, to pull down or destroy that house, that will save the nearest houses or the person was standing nearby or in the houses. So what happened? He tried to destroy or pull down the houses in order to prevent a further conflagration, spreading of conflagration, or further preventing caused any harm to any other person. So that he does not have any guilty intention. So he has done in all the things in good faith, and it does not have any mens rea. So that is the necessity. So you have to destroy that house with the necessity. That this is the thing the section is saying, that if anything done in the necessity by observing good faith or without any criminal intent, that person is also excusable and will be exempted from any criminal liability. Okay. There is a case also, you can go through it, R versus Dudley and Stephens, 1884 case. Okay. You can go to the book. There is a very big case, very famous case. It also mentioned the tort as well. Now there is another important part is 82 and 83. It's all about infancy or infant child, whether they'll be liable for any offense or not. Now come to 82 and 83. There is a maxim is that doli in capas, that define that saying that doli there is a maxim. Come to the 82 provides I'm just first I'll read the section. 82 is saying act of child under 7 years of age. That means nothing is an offense which is done by child under 7 years of age. That means that he'll be thus the child below the 7 years of age, he or she has been exempted, fully exempted from any criminal liability. It has been presumed that the child below the age of 7 years cannot have any mens rea. If he or she doesn't have any mens rea, then he or she will not be held criminal liable. So this 82 exempts child from any criminal liability who was under 7 years of age. There is a case, Hiralal versus State of Bihar, 1977, CRL Criminal Law Journal. So you can put on there, mention the case, Hiralal versus State of Bihar, 1977, CRLJ. Then section 83 is saying, act of child above 7 years and under 12 years of mature of understanding. Nothing is an offense which is done by a child above 7 years of age and under age of 12 who has not attained sufficient maturity of understanding to judge the nature and the consequences of his conduct on the occasion. Is saying that nothing is an offense which is done by a child above 7 years age and under 12. That means saying the person who is above 7 years age but under the age of 12 years and it does not have any maturity of understanding, it does not know the nature of the act that he has been committed. In that cases, he or she will be exempted from the criminal liability. There are another case is that, as I said, Hilalal versus State of Bihar. I'm just repeating that case again. The accused child of 11 years old threatened the deceased that he would cut him into pieces. Accordingly, the accused killed him with a knife. The Supreme Court upheld the conviction by the lower court on the ground that the accused child had sufficient maturity of mind and understand the nature and consequences of his act while stabbing the deceased. So in this case, what happened? The Supreme Court found that the person, though he is in under 12 years of age, but he has the maturity of understanding. That means he knows the consequences if I will stab or stab the person. The person will be bleeding or will be maybe death. So in order to based on that point, maturity of understanding, the court held him guilty. So there is only exception is that if whether and person is above 7 years of age and under 12 of years age, and it does not have any mature of understanding, in that case only that person or that child, the juvenile, has been exempted from any criminal liability. So this is all about 82 and 83. This is a very important part. After person, then come to the insanity or mental abnormality. It's this chapter saying is also that if any person does not have mental, he or she doesn't have any mental capability to know the nature and consequences of the act, what he is doing, what he or she is doing, is also exempted from criminal liability. And it's two part. If the voluntary, there is two part. There is voluntarily or involuntarily. So I'm going to read one by one. From to section 84. After person of unsoundness of mind. Unsound mind. Nothing is an offense which is done by a person who at the time of doing, by reason of unsoundness of mind, is incapable of knowing the nature of acts. Is by reason of unsoundness of mind. Second is incapable of knowing the nature of the act, or that he is doing what he is either wrong or contrary to the law. So he does not know what he is doing and contrary to the law. In these circumstances, the person will be excusable or exempted from any type of criminal liability. There is another case, M. Norton case, rules. You can go through it. The book. The fact is that I'm just telling the fact and judgment. Daniel McNaughton, the accused in the instant case, murdered Mr. Drummond, the private secretary of Sir Robert Peel, then the Prime Minister of England, thinking by confusing that Mr. Drummond was Sir Robert. He shoot one person by believing that he is another. So Robert Peel, he was tried of murder. So on behalf of the accused, the defense counsel declared that the accused due to insanity because he does not know what he is doing. Insanity was not able to know that he was violating the laws of God and man. So it was established that the accused lost his power and control while committing an offense, and he was laboring delusion of medical report was produced as a report. So the medical evidence established that the person who was committing the crime, he was not in a mental state of know the nature of the nature of what he is doing, the nature and the consequences of his act. He does not have any idea because he doesn't have any mental status to observe anything. So in that background, in that by basing on that evidence, the basing of that medical evidence, the Lords or the Supreme Lords of British Council exempted him from criminal liability. That is called law of insanity. If it does not know understand the nature of that, then he will be, he will not be held liable for any type of act, any type of criminal act. There is another. Come to the section 85. I'm just going to brief regarding about intoxicated person ingredients about the section 84. To plead insanity of defense, the following conditions are to be satisfied. To plead insanity is a defense, as in case of R versus McNaughton. So you have to prove whether you have a mental state or not. You have to, physical. You have a good mental state or not. You have to prove the following essential elements. First, the accused is of unsoundness of mind, that he does not know the nature of the act he was doing, as I said, that he is doing what is either wrong or contrary to the law. He does not know, what he is doing, and these three requirements must be fulfilled before the honorable court by for getting any type of exemption from criminal liability. So he or she must have proved these three things before getting an exemption. So if she has proved these things, then he will be get exempted from any criminal liability. Otherwise, he won't be exempted. Then come to the section 85. That is 85 is saying about it. You have to go read 85 and 86 because it's all correlated. Drunkenness or intoxication. Now I'm just reading the 85 section. Act of person incapable of judgment by reason of intoxication caused against his will. Nothing is an offense which is done by a person who at the time of doing it is by reason of intoxication incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to the law, provided that the thing which the intoxicator was administered to him without his knowledge or against his will. There is a maxim is the non-compos mentis. Please write down. This part is dealing with the maxim that is non-compos mentis relating to the intoxication or drunkenness. So there is saying 85 is saying that I'm reading the second page. Read that again. Nothing is an offense which is done by a person who at time of doing it by reason of intoxication. First, by reason of intoxication. Second, incapable of knowing the nature of the act. He does not know what is doing, the nature of act, and he is doing either, and he also does not know whether he is doing either wrong or contrary to the law. Provided that the thing which is intoxicated him was administered him without his knowledge or against his will. This four condition must have fulfilled for getting an exemption from criminal liability. First, the reason of there must be intoxication state, mental state, incapable of knowing the nature of act, and he's doing either wrong or contrary to the law, he doesn't know, and provided that the intoxication or drunkenness has been done is involuntarily or against his will. That means that he has the state of mind and by drinking. Drunkenness has not been caused by his or her own will. He has been possessed. He has been forced against his will. If this condition has been satisfied, then the court will exempt that person from any type of criminal liability. Okay. So this is another exception of by drunkenness or intoxication. And then second is saying about same thing, the same fact, but there's little bit different. 86 is saying that offense requiring a particular intent or knowledge committed by one who is intoxicated. Just reading the section. In case where an act done is not an offense unless done with a particular knowledge or intent. First, an act done is not an offense unless unless done with a particular intent or knowledge. A person who does act with a state of intoxication shall be liable. It would be dealt with as if had the same knowledge it had been it would have had if he had not been intoxicated, unless the thing which is intoxicated him was administered to him without his knowledge or against his will. This is called 86 is saying about the voluntary drunkenness. That means he has drunkard. He's done, the reason of mental state is he has been intoxicated because he has doing his by his own will. That is voluntary drunkenness. Voluntarily drunken, the voluntary take drinks, and if in that circumstance he has committed anything, then that person will be held liable for his act, because it's he has been, the reason of mental state, abnormal state, because he has drink it by his or her alone, by his or own will. So that's why he will be held liable for anything or any offense done by him. I'm just clearing out one another time. When a person gets intoxicated voluntarily, that is by taking drinks or drugs with his full knowledge, is called voluntary drunkenness. So if in that situation, if has committed any type of crime, he will be held liable and he won't get be exempted. But if the mental state is by reason of involuntary drunkenness, that means has been by another person against his will. In that case only he will be get exempted from the criminal liability. So that is the only main basic difference is 85 is against his will, drunkenness against his will, and section 86 is by by his own will. So that's the basic difference. That's two are the basic difference. There is a case is that Basudev versus State. We can go to the book AIR 1956, Supreme Court 488. There's a very famous case, Basudev versus State, and AIR 1956. So this is all about just on 76 to 70. I'm just going to repeating another time. Mistake, there is two part, mistake of fact and mistake of law. That is 76 and 76 have to read section 76 and 79 together. Then Judicial Act, that means the act, the act of judge when acting judicially. They are not going to be held responsible for anything, any order or judgment. 77 and 78, 78 also saying that the authority who is carrying out the judge's order, they also exempted from any type of criminal liability. 77, that is comes under Judicial Act 77, 78. That accident, section 80, it is wholly exempted. If any, they have to fulfill 2 or 3 conditions without without any criminal intent, have it done good faith or with proper care and concern. If the person, the accuser, fulfill or prove or establish that the 3 conditions fulfilled, he will be exempted from any type of criminal liability. And the necessity is that the person committing such act may be which is lost to the opposite party, but he has done it with a good intention to prevent the further harm or further harm. He has done this act. So he has, and it is the necessity to prevent the such further harm. So 2 things have been done in good faith and to prevent further harm. And that it doesn't have any mensia. If 3 things are fulfilled, then he or she will be get exempted from any type of criminal liability. In infancy, that is Tolin Capus, section 82 and 83. To think of the child under the age of 6-7 years won't be held responsible, won't be held liable any type of criminal liability, because the child under the age of 7 years to presume that he or she doesn't have any menstruation. But section 84, 83 saying that child above 7 years but under 12 years, if he or she have a mature of understanding, matlab means he or she know the nature of that. He have sort of mature that if I stab a person, he may be killed. So in that, if the court find out that the person or the child knew the consequences of his or her act, then at that only in that case they will be go to the juvenile custody. Will be the charge will be held liable, criminally liable. Otherwise, they won't be held liable. Then then is 84 insanity. 2 part, voluntarily or involuntarily. Voluntary is saying that if the person taking drugs or consume alcohol by his own will, and in that circumstances, if he or she has done any crime committing in that circumstances, then he will be held liable. Otherwise, if there is involuntarily, that means the drunkenness or the alcohol or any type of drugs has been giving to him or her without his consent, or again without his or her consent, without or not without his knowledge or without against her will. In that case, if he or she doing have any act and committed an offense, then he won't be held liable in that circumstances. Then that is drunkenness, section 85 and 86. Now come to the, so now I've taught about from 76 to 86. Now come to the consent part. There's nothing, consent is we just have to read about it. There's nothing need to explain. Just time, just in order for a better understanding, I'll just read it out. Consent 87 to 87, 88, 89, and 90, 87 to 93. It's all about deals with consent. Act not intended and not known to be likely to cause death or give us hurt done by consent. Just give me a minute, second. According to section 87, any harm other than the death or grievous hurt, even though intended or known by the door to be likely to be caused, will not be an offense under the following conditions. Please read carefully. Section 87, the object is saying that any harm other than the death or grievous hurt, anything is happening, any harm, any cause committing an offense other than grievous death or grievous hurt, even though intended or known by the door means the offender to be likely to be caused, will not be an offense under the following conditions. If I fulfill following conditions. First, if the act is done without any intention of causing death or grievous hurt. If his or her act does not have an intention of causing death or grievous hurt. Second, harm is caused to any person with his consent. Harm is caused to any person with his consent, and person giving consent is above 18 years of age, and the consent given may be express or implied. So there is one maxim based on that maxim which has been based on section 87, that is voluntary non-fit injuria. You also read it in tort, which means no act is actionable if it is expressly or impliedly consented. If someone gives consent to do such thing, that action is not be held liable. In other words, the wrong or injury suffered voluntarily is not actionable. That means if someone has voluntarily caused or harm himself, except death or grievous hurt, they won't be held liable. So the maxim based on two principles. First, that every person is the best judge of his own interest. That means if for example, I know what is wrong for me, what is right or wrong for me. If I'm doing something to be myself with my own consent, then I won't be held liable. And second is no man will consent to what he thinks harmful to himself. Simple. No man will consent to what he thinks harmful or himself knows, he or she knows by himself that what is harmful, what is not harmful. So in this circumstances, they won't be held liable whether they have been consented or not. So that's why the section 87 is also saying that any harm, but that is to accept that you have to just remember section 87, that's except two, that is death or grievous hurt. Except from that, the other won't be held responsible or won't be held any criminal liable. And section 88. Section 88 is saying that act not intend to cause death done by consent in good faith for person's benefit. Section 88 is saying about Section 88 protects any harm other than it also protects any harm other than intentional death. If the act is done by the door or offender in good faith for the benefit of the consenting person, if any person doing something for his good faith with a good intention, the consenting person must be at least 12 years of age, and the section protects what is the main object? The consent. What is saying that protects the section 88 protects harm other than intentional death. If the act is done by good faith, for example, when a surgeon is doing a surgery. In surgery, that victim or that patient may be dead. If the person must be dead, then the doctor will not be held liable for his death. So in order to protect that this type of situation, this type of litigation, the IPC has inserted this part, the section 88, that protects any harm other than intentional death, and only in case of that if the act is done by the in good faith and for the benefit of the consenting person. That means the surgeon, the patient consent that when giving his or consent that if anything happens, then the doctor or surgeons are not won't be held liable, criminal liable for their act, because the doctors are only try to work. The duty is to try to save that patient. If anything happens in negative, that they won't be held liable. So in order to protect this type of situation, in order to complicate the complicate litigation, so IPS inserted the section 88. There is a case, Emperor versus Suraj Valley, criminal law journal. There is seven criminal laws CRLJ, that is 306 page 306. In this case, what happened? The accused, a doctor in good faith for the benefit of his patient, operated the eye of the patient for cataract. He was, the doctor was operating his eye in order to, for a better vision, but it resulted in loss of eyesight. So in an action against the accused, it was held that the act of the accused was not offense and was acquitted under section 88. So though he has done done in good faith, his act was in good faith. There is no criminal, no criminal intention, and there is no criminal mind. So in that case, he has whatever he is doing only for for his he is just treating a patient. So in that case, the court rejected the contention of the accused and granted exemption to the doctor. So this is all about, let's read section 88. Just remember, if though consenting part will be get benefited by the person consented, if though he has consented, they are also protected by the IPC. Then come to section 89. Section 89 is saying act done in good faith for the benefit of child or innocent person by or by consent of our guardian. So section 99 provides the protection in respect of harm caused to a person, child below the age of 15 years, below the age of 12 years of age, or a person of unsoundness of mind by his guardian himself or other person with the consent given by the guardian. So to invoke this section, to getting benefit from this section, this act must be done in good faith for the benefit of child or the person of unsoundness of mind. So whatever to get exempted under section 89, there must be a fulfillment of the act must be done in good faith, and the child must be not be the above age of 12 years. Then you can get exempted under section 89. Then come to section 90. Consent known to be given under fear or misconception. So just reading, a consent is not such a consent as intended by any section of this code if the consent is given by a person under fear of injury, under a misconception of fact, and if the person doing act knows or has reason to believe that the consent was given in consequences of such fear conception. Or conception or consent of innocent person. That is, if the consent is given by a person who, from unsoundness of mind or intoxication, is unable to understand the nature and consequences of that which he has given consent. Second, consent of child. Unless the contrary appears to the context, if the consent is given by a person who is under the age of 12 years. I'm just sorting it out, this section, because it is a very lengthy section. So I'm just please listen carefully. I'm just setting it out. Limit that section from 3 to 4 lines. According to section 90, consent is not to be a consent if it is given. A consent is not said to be a consent if it is given under fear of injury or misconception of fact. Under fear of injury or misconception of fact. Second, by a person of unsound mind or by a drunken person, provided he is unable to understand the nature and consequences of that of what he is consent. Third, by a person under the 12 years of age. That means any consent as given by in these three conditions, that won't be considered as consent. The person, when you're something, I'm getting someone uh, by forcing them to take my consent, that is not applicable. Second, unsoundness of mind, drunkenness, because it doesn't, he or she doesn't have any state of mind, mental state to give consent, that won't be considered as consent. Second, the person who is under the age of 12 years age, that won't be a consent. So this in these three circumstances, consent given by these three conditions, that won't be considered as a consent, and they won't be held liable for that. They'll be get exempted. There is a case, Dashrath Paswan versus State of Bihar in 1958, CRLJ 548. I'm just reading the fact, 3 to 4 lines. The fact is that in this case, the accused, under utter distress, wanted to put an end of his life by committing suicide. The accused, by frustrating his life, he wants to commit suicide, but his wife wanted to ask consent him to kill her first and then to commit suicide. Now his wife is saying that first, before you committing suicide, you have to kill me first. You have to kill me, then you commit suicide. Accordingly, he killed her first and was caught before committing suicide. After that, he killed his wife, and before going to kill by him killing himself, he got caught. And it was held that the consent of the accused wife was free consent within the meaning of exception 5 to section 300 IPC. So that consent will not be a valid consent. So he will be held responsible for that killing. Okay. So this is all about the consent part only. Section 90, and we come to the section 91. Section 91 is an exception of section 87, 88, 89, and section 92 and 93. It's still to be deal with constructive consent. 92 and 92 is saying, sorry, 91, huh? That is an exclusion of act which are offense independently of harm caused. That means the exception of section 87, 88, and 89 don't extend acts which are offenses independently. There's a meta problem. So offenses independently of any harm which they may cause or to be intended to cause or to be known to be likely to cause the person giving the consent, and on whose behalf the consent is given. It's saying that it is total, section 92 is totally deal, 91 is an exception to 87, 88, 89, and 92. Act done in, that means, and section 9, the 91, 92 is correlated. You have to read the 92, 92. 92 is saying act done in good faith for benefit of person without consent. That means 92 deal with act done in good faith for the benefit of person without consent. He will be exempted. That means if a person doing something, acting something, though it is offensive, but he has done with a good faith and the benefit of that person, then he will get exempted from any criminal liability. For example, a surgeon performs operation of a child as there was no time to obtain consent of his parents. For example, there is a child. There was no time to getting consent from their legal guardian or parents or anyone else. In that circumstances, the doctor operates that child, and the surgeon and say the child has been dead. So in that case, the doctor won't be liable, surgeon won't be liable because there is no time for getting in consent. So doctor have to do, the doctor has done what he has to do because it is duty to, the first priority is to getting the consent, to take care of the patient. So in that circumstance, because he has done in good faith, the act has been done, though it has been offensive if the child has been dead, but in that case, the doctor won't be liable because he has done in the act his part in good faith and without any criminal intent, and though it has not been a valid consent. still the conductor won't be held responsible for that act. So this is the important section of from 76 to 96. Then 92, then equal to 92, 93 now. I'm just reading out the 92 or 93 part, because 92 and 93 pockets communication made in good faith. For example, I'm just reading out the section, then you will get understand. Nothing is an offense by reason of any harm. Nothing is an offense by reason of harm which it may cause to a person for whose benefit it is done in good faith. Good faith, even without person's consent, if the circumstances are such that it is impossible for that person to signify the consent, or if that person is incapable of giving consent and has no guardian or other person in lawful charge of him from whom it is possible to obtain consent time for a thing to be done in benefit. Is saying that if any act done which is done in good faith, or good faith and benefit of person's consent, persons without consent, in that sort also they won't be held responsible. They won't be held responsible for that act. So though it is because it has been done in good faith and without his consent. Consent is not necessary if the person acting in good faith. Any negative result, if any crime has been, any offense has been, that the act may be an offense, but in these circumstances, they won't be held liable for that act. So select go to the 96 to 106 because it took more time. I think 70, 96 and to if you complete from 106, if you allow, it will take more than half an hour. Shall I continue?
No, sir, you can continue with the 96 to 106 part.
So I continue. Huh?
Yeah, we can continue from the private defenses.
Okay, now this is one of the most part, the demanding part. What is the right of private defense? People are asking so many questions in this part. Right of private defense. So right of private defense in the means, private defense means to prevent himself from anything, to prevent himself or any other person for destruction by the physical or by property. So you have right to defend yourself as well as the other. The defend in the self, that does not include only physical part, it's also the property. Destruction any part in that will also comes under this right of private defense. I'm just reading that section 96. So I'm just, before going to the 96 right of private defense, I just want to give an introduction about right of private defense. That the law confers right on every individual to defend his life, liberty, and property when he is confronted with an imminent danger or unlawful aggression. When he is imminent danger or unlawful aggression, he has a right to protect himself. So right to private defense means committing an offense in exercise of one's own right to defend, protect his life, liberty, or property, as well as the other. For example, A attacks B to kill him. B, in order to save himself, kills A. So here B is said to have exercised his right of private defense. B can plead the defense of right of private defense to get exemption from criminal liability. So the right of private defense is designed with a social purpose and should be exercised within the certain limits that we will read from section 96 to 106. Everyone cannot be taking plea that you want to kill me, then I kill her. So that with limitation part we will read from section 96 to 106. What proportion we have to take risk, and what the crime, and what proportionate we have to act according to our proportionately. So that will read. Hence, recognized in the section the 96 to 96 to 106 is about the provisions related to right to private defense. There is two principles. The right of private defense is based on two principles. First, everyone has a right to defend one's own body, body and property, and also defend other body and property at the time of immediate necessity. First, second, the right cannot be exercised to cause harm to another as revenge. That your acts shall not be a revengeful act. In other words, the right to private defense can be used as a shield, not as a sword. So two parts. The right of private defense available to each and every person. That does not mean that must be arbitrary. And second, your act shall not be a revengeful act. It, that's why there is a word. Your defense can be used as a shield, not as a sword. So now come to the section 96. 96 is saying right to private defense of the body and of property. Like I said, every person has this right subject to the restriction contained in section 99. We'll read after that what is saying section 99. Subject to the 99 to defend first his own body and the body of other person against the offense affecting the human body. And secondly, the property, whether movable or immovable, of himself or any other person against an act which is offense, falling under definition of the offense against property, that is theft, robbery, mischief, criminal trespass, etc., which is attempt to commit theft, robbery, mischief, or criminal trespass. So right to private defense is included of both body and property that may be movable or immovable. And section 97, section 96 is defined the definition. I'll just remember section 97. Okay, so 96 is nothing, just definition part. 97, then come to 98. Right of private defense against act person of unsound mind. This is very important. 98 is saying that when an act which would otherwise to be certain offense is not that offense by reason of the youth, the want of maturity, of understanding, the unsoundness of mind, or the intoxication of the person doing that act, or by reason of any misconception on the part of the person, every person has the same right of private defense against this act, which he would have if the act were that offense. Come to the illustration, then I will explain the section, because illustration will get better understand from illustration. Z, under the influence of madness, attempts to kill A. Z, under the influence of madness, attempts to kill A. Z is guilty of no offense, but A has right. I has the same right to private defense, which he would have if Z were sent. That simply means if unsoundness, so person, so mad people coming to kill you, that means you have right to defend you are by yourself. So in that circumstances, if anything happen, then you won't be held liable, you will be get exempted from any type of criminal liability. And second example, A enters by night his house, which he is legally entitled to enter there. In good faith, taking A for a housebreaker, attacks A. Here, Z by attacking A under this misconception commits no offense, but A has the same right to private defense, Z, which would require the same thing. If anything happens, you have the right of private defense to your body or property. Yes, comes to section 99. 99 is saying acts against which there is no right of private defense. Act against which there is no right of private defense. Let's listen carefully this one. There is no right of private defense against an act which does not reasonably cause the apprehension of death or grievous hurt if done or attempted to be done by a public servant acting in good faith, or of grievous hurt if done acting in good faith, the public servant acting in good faith under glory of his office, though the act may not be strictly justified by law. There is no right of private defense against an act which does not reasonably cause the apprehension of death or grievous hurt if done or attempted to be done by the direction of a public servant acting in good faith under the color of his office, though the direction may not be strictly justified by law. Section 99 is saying, if the person who is acting under the color of his office, if he's done anything in the during the color, you cannot defend. Suppose a police officer wants to arrest you. If he wants to arrest you, that means you cannot comply. You cannot claim that I have a right to private defense because you have committed a crime. Then the police officer is a public official. He's in the duty. He has in the color of his office. He have to do what the order comes from. He has doing lawfully. So if anything public officer doing anything lawfully, then don't have any. You cannot claim that I have to restrain myself. I have to restrain. I have to restrain the others to others. That will be illegal. So in that case, you cannot claim the right of private defense. That's why it says that act against which there is no right of private defense. So that means as I said, the private defense has been now in this section 98, now section 99. The privatization have some limitation. I'll just explain to it more for a better understanding. Section 99 lays down that the limitation on the exercise of the right of private defense. Now, what limitation you have to use your private defense? You have to use to defend yourself. The limitation or the restriction has been imposed in this section. Private defense, that does not mean that, as I said earlier, you cannot use that power arbitrarily. You have certain limitation. First, the first two clause saying that the section 99 states that first, there is no right of private defense against act done or attempted to be done by direction of a public servant. If anything done by public servant, you don't have any private defense. But second, the public servant must have done act in good faith or under the color of his office during the discharge of his duty, even though act may not be justified by law, then you don't have any right to private defense. So in this section, the right to private defense has been limited. Simple. If a person discharging his duty, he has done anything which is not justified by law, but he cannot claim of right of private defense. And second, direction of any public servant. If the public servant directing any court's order, any order from the superior authority, he cannot claim of right of private defense. There is a case, Krishna versus State of Madras, 1968, 22 ST 258. There is in this case, what happened? The accused, a terror abducted and assaulted the cell tax officer who inspected the shop and attempted to seize the counts. So the cell tax officer attempted to seal or inspect that shop. So the accused pleaded the defense of that right of private defense. He held that accused guilty and did not allow him the defense. So the public officer, that's the public officer deemed he is discharging his duty, that is, don't have any right of private defense to oppose themselves. If you are going to oppose, then it will be done an offense under the law. Another important is section 100. Section 100 is saying that when section is when such right extend to causing harm, any harm other than death. Sorry, the 100. Sorry, there's 101. 100 is saying when the right of private defense of the body extend to causing death. In what circumstances the right of private defense extended to causing death of a person? This is important. 100 and 101 is the most important part. So I'm going to read the section 100, saying that the right of private defense of body extends under the restriction mentioned in the last preceding section, that is section 99. The limitation preceding section to the voluntary causing death or any other harm to the assailant, if the offense of which occasion of exercise of right to be of any of the description herein after enumerated, namely, first, such an assault as may be reasonably cause the apprehension that death will otherwise with the consequences of such assault. Please read the definition. When the right of private defense of the body extend to cause death. In these circumstances, we can take the right of private defense which extend to cause death. First, such an assault as may be reasonable. First, such an assault as may be reasonably cause the apprehension that the death will otherwise to be consequences of such assault. In the circumstance that such assault may cause the death of that person. Second, such an assault may be reasonably cause the apprehension of that previous hurt will otherwise the consequences of such assault, due to such assault that previous hurt may be caused. Thirdly, an assault with the intention of committing rape. People are trying to rape someone. That is the action. The point that lady have the right to defend himself because of death. If the assault and with an intention of committing the rape. Fourth, an assault with the intention of gratifying unnatural loss, something that even sexual harassment, gratifying unnatural loss happening previous hurt. Fifthly, an assault with the intention of kidnapping or abducting. Any person try to abduct or kidnapping, you have the full right of private defense. And sixthly, an assault with the intention of wrongfully confining a person under the circumstances which may reasonably cause him to apprehend that he will be unable to have recourse to the public authority for his release. He does not have any choice. He has been confined. In that case, also, he has a full right of private defense. Seven, an act of throwing or administering acid or attempt to throw an administered acid which may reasonably cause apprehension in that previous spot will otherwise be consequences of. In this seven circumstances, the person have the right of private defense to cause death. And this is, and apart from this the seventh condition, you don't have any right of causing death. So that's why in section 99 the private defense has been limited, but in section 100 the limitation has been extended in seven circumstances. In seven circumstances, you can use your full right of private defense. Okay. Then come to, there is a case in section 100, Karamat Hussain versus Emperor, AIR 1930 AR case, AIR 1938 to 269. In this case, the accused, in order to save or protect his sister from mercilessly beating by her husband, intervened and killed him. So it was held that the accused was entitled to a right of private defense under such circumstances. And another is that R versus Rose, 1884. There are a lot of cases in this section. 1884, 15 CC 540. The accused shot and killed his father, whom he believed to be cutting the throat of his mother. So in order to save his mother, he killed his father. So the accused was allowed to the right of private defense to protect his mother against his father's act. So these are the circumstances, these are the seven circumstances under which you can use your full right of private defense. Come to section 101. This is also one more important part. When such right of private defense, such right extend to causing any harm other than death. The section 100 is saying about the death only. Section 101 is saying that other than the death. So section 101 is saying that if the offense be not of any kind of descriptions enumerated in the last preceding section, that means section 100, the right of private defense of the body does not extend to the voluntarily causing death to the assailant, but does extend under such restriction mentioned in section 99, that is discussed earlier, to the voluntary causing to the assailant any harm other than the death. That means section 101 is saying that provides in the absence of any circumstances laid down in section 100, the right of private defense is limited by causing harm. Causing private defense is limited also as limited in this section, causing death other than causing death. Then section 102 is commencement and continuance of the right of private defense of the body. That is more important. People just been asking in this case a lot of questions when the right of private defense is commenced. The answer is the right of private defense of the body commences as soon as a reasonable apprehension of danger to the body arises from an attempt or threat to commit the offense. Underline the part. The right to private defense, the body commences as soon as a reasonable apprehension of danger. As soon as you feel like there is apprehension of danger to the body arises from an attempt or a threat to commit the offenses, though the offense may not have been committed, it continue as long as such apprehension of danger to body continues. Though the act has not been committed, but you have an apprehension that the thing has been committed, the offenses was going to commit. So in that case, your right of private defense arises at that time or commences at that time. So this is the commencement, and it will continue up to the danger suppressed, unless the danger suppressed. So you can continue up to the last end. So this is tell about the commencement of the right of private defense. 102 and 103 is saying about when the right of private defense property extend to cause death. The right of private defense of property extend under the restriction mentioned in section 99. The voluntary causing of death of any other harm to the wrongdoer if the offense, the committing of which or attempting to commit which occasion exercise the right of an offense or any other description hereinafter enumerated, namely faster robbery or the saying. When the right of private defense of property extend to cause death. So the right of private defense of property extend under the restriction mentioned excluding section 99 or the voluntary causing death of any other harm to the wrongdoer, that means the offender. If the offense, the committing of which the attempting to commit which the occasion of the exercise of this right, the be an offense, any other description I have mentioned enumerated, namely first is robbery, or the secondly, the house breaking at night, thirdly, the mischief, or fourthly, theft, mischief, or house trespass. Under these circumstances, as may be reasonable cause apprehension that death or grievous sort will be the consequences if such right of private defense is not exercised. So you can use in case of property also. So section 100 and 103 are correlated. Section 100 is saying the death in case of 100 is saying the right of private defense of body extends to causing death, and 103 is saying and the right of private defense of property extends to causing death. So in this their body there is mentioned in 7 circumstances you can use your full right of private defense. So when you will read by combining section 100 and 103. It is the body. Section 103 deals about the property of causing death. So also in 103, you can use your full right of private defense that may be caused death. Okay. Then come to section 804. When the right of private defense of property extends causing harm, when the section 104 is saying about when such right of private defense of property extend causing any harm other than death. So 104 says that the theft, mischief, or criminal trespass does not answer the description in section 103, then the right of private defense of property does not extend to causing death, but it extends subject again section 99 to voluntary causing any harm other than the death. So that means someone is trying to pickpocket. That does not mean you kill that person. So this thing has been mentioned in property. Someone has been trespassed on your property. Someone entered in your barricade, break your fence and enter to your barricade. That does not mean you have to kill that person. So that's why the section has mentioned only that other than the death. We can use your right to private defense, but instead of death, causing any death. So this is all about section 104. And section 105 is the same thing. Commencement and continuance of right to property in case of property. As same thing in the body, that is same commencement, and same thing in property. The right of private defense of property commences when a reasonable apprehension of danger of property to the commences. So the right of private defense of property against theft continue till the offender has effected is retreat with that property, or either assistant or public authority is obtained, or the property has been recovered. So the right of private defense commences as soon as if there is an apprehension that there is theft, or theft or trespass has been committed, then the right you can use that right of private defense. Then section 106, the last one, right of private defense against a deadly assault when there is a risk of harm to innocent person. If in the exercise of the right of private defense against an assault, which is reasonable causes apprehension of death, the defender to be situated that he cannot effectively exercise the right of private defense, that exercise the right without risk of harm to an innocent person, he has a right to private defense extend to the running of that risk. For example, he is attacked by a mob who attempt to murder him. A is attacked by a mob who attempt to murder him. He cannot effectually exercise the right of private defense without firing on the mob. Without firing on the mob, and he cannot fire without risk of harming another person. Younger children who are mingled with the mob. So a commits no offense if by firing he harms any other children. So in that circumstances, he has not been liable for that firing. So in this case, he has the right of private defense, defend herself. So this is all about right of private defense. So if any doubt, I think it's almost complete. If you have any doubt, you can ask me. If you have any doubt in sections or meaning or anything else, you can ask me. Hello. Any doubt of any section? Doubt, you can.
No, sir.
No, sir.
So, shall we finish that then topic then? Yeah, it's done already. 76 to 106, the whole part of general exception. This is a very important part. If you go please read that again by yourself in home, then you'll get better understand. Please read by combining the section, because some sections are correlated. So if you have read by relating section by section, then you get better understand. So end that.
Thank you, sir, for your informative session. So all the participants who had given their mail ID and registered for the workshop, their materials and the seminar certificate will be sent to the mail. So all can leave now. The workshop is over.
Thank you so much to all your students. Hope will
Thank you, everyone.
Better. Thank you.
Thank you, sir.
Thank you.